All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All we have cause to plead, draw near, give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. Justice Muniz cannot be in the court today, but he will be participating in the decision of this case. As yesterday, today's proceedings after this first case will be proceeding remotely. But the first case today is Hayslip versus U.S. Home Corporation. Nice counsel for the petitioner.
Thank you, Your Honor. May it please the court. Josh Burnett on behalf of Shane and Laura Hayslip. We're here today, Your Honors, because the Hayslips, as subsequent purchasers of their home, never agreed to arbitrate with U.S. Homes. The arbitration provision in the remote deed from the original sale of the home by U.S. Homes to the original purchasers does not run with the land because it does not touch and concern the land. It's not a real covenant, it's a personal covenant. And if the court were to enforce the arbitration provision upon the Hayslips who did not agree to it and were not in privity with U.S. Home, it would infringe upon their constitutional rights to a right to a jury trial as well as access to the courts.
Counsel, what would be the consequence of assuming, as I gather you're asking us to assume, that the Hayslips either did not review the deed or are not to be bound by the conditions in the deed?
Correct, Your Honor. The Hayslips were not aware of the arbitration provision in the remote deed to which they were not party to. Yes, the deed was in their chain of title. However, they were not aware of that provision. And essentially, U.S. Home is arguing that the Hayslips had constructive notice just by virtue of it being in their chain of title. However, Your Honors, I would suggest that that is not sufficient to require the Hayslips to give up a constitutional right to a jury trial and access to the courts.
Well, but my question is, what's the consequence of other conditions that they might permissibly, given your reading of the law, say they had no constructive awareness of, even though they are in the chain of title? Like, for example, the boundary lines.
Well, and Your Honor makes a great point. Justice Currill, the types of provisions that you're speaking to are restrictions, easements, things that do touch and concern the land. However, this arbitration provision has nothing to do with the use or the enjoyment of the property itself. It does not touch and concern the land. All it does is provide a mechanism by which the owner of the property can later on seek damages as a result of any dispute related to the construction of the home.
Well, why wouldn't it touch the property by providing a restriction on how it is they're to pursue legal remedies in the future? Why isn't that a touching and concerning the property?
It has no impact whatsoever on the way in which they can use the property, what they can do with the property, how they can use the property, what activities they can conduct on the property.
Well, you're arguing that this is some kind of restriction on how they can pursue legal remedies. So isn't that some type of restriction that affects the property?
It affects the owners. It affects their ability to have access to the courts and the right to a jury trial. However, it does not affect the property, Your Honor, although the issues raised in this claim relate to a construction defect and compliance with the building code by U.S. Homes. It's a statutory claim under 553.84 Florida statutes. It affects the way in which they can pursue that claim. It has no impact whatsoever on their use of the property.
And it certainly relates to their use and enjoyment of the property, because if it's about remedying a construction defect, an alleged construction defect, and the construction defect obviously has an impact on their use and enjoyment of the property. So, candidly, I mean, this concept of touch and concern is a rather capacious, vague concept. I mean, the way it's been applied in different contexts, I mean, obviously, there's some outer boundaries, there's some things outside of it, but it is not a sort of bright line test. So you would concede that, wouldn't you, counsel? It's
not perfect, Your Honors. It's not perfect. Justice Kennedy, I do believe, however, it's well known. It's been the standard has been applied effectively.
And you would also concede that we have said that we really don't apply it in a technical way. Didn't we say that in Bessemer?
Yes, Your Honor.
Okay.
Yes, you did. And I understand that. At the same time, what we're talking about here is effectively doing away with any necessity that any provision with any deed touch and concern the property whatsoever, and opening the doors to builders, any homeowner, any owner of real property at their whim, inserting into a deed any provision that they deem fit, whether it actually affects the property or not, which I would submit would create an undue burden on the real estate market in the state of Florida and any homeowners or property owners in the state of Florida.
Well, let me ask you this. I'm trying to figure out how your arguments fit in with restrictive covenants related to homeowners associations. You know, we've got homeowners associations all across the state that are based on deed restrictions. They set up a scheme for kind of the management of property and common areas and things like that. And from that, we can people have to make payments. But under the way you're arguing this, if you almost so you're saying that, well, if they didn't know about that, they don't have to participate in that.
No, and that's not really the argument, Your Honor. Justice Kennedy, the argument is that if they are going to be bound by an arbitration provision which forces them to give up the right to a jury trial and their access to the courts, they need to have specifically agreed to it.
So that would be an arbitration that would include, your argument includes any sort of arbitration condition. So it would be an arbitration provision that related to a homeowners association that's established in restrictive covenants, and the arbitration of disputes arising in connection with the enforcement of the restrictive covenants.
And Justice Kennedy, I can see how that would be a different situation. And in that situation, you're actually dealing with a provision, a covenant, a restriction on the use of the specific property. And that would be intertwined within the ability to put that provision within the covenant. Here we're talking about putting a restriction on a remote owner of the property, which does not touch.
But those are all. I mean, we're talking about remote owners of the property in the example I gave, right?
Certainly. And in that example, Your Honor, also those folks know about the restrictive covenants that affect their property.
Well, they might not. They might not have actual knowledge. I mean, there are people that obtain title through some quitclaim deed. Be nothing in the deed they got. But there is this statute, section 695.11, which basically says if something's recorded in the official records, it's notice to the world of what's in the records. And it's shall be noticed to all persons, is what it says there. And that is a fundamental principle about the way property transactions are recognized and the consequences of deeds and other documents that are recorded. Is that correct?
Yes, Justice Kennedy, and I would agree that affects. That touches and concerns the property. Those issues with respect to the covenants, conditions, and restrictions that we're talking about. And this court in Seifert specifically said that no party may be forced to submit a dispute to arbitration that the party did not intend and agree to arbitrate. And in this situation, what U.S. Holmes is arguing is that constructive notice is enough to show that the homeowner intended and agreed to arbitrate.
Well, in Seifert, we were dealing with the Florida Arbitration Code, and here we have specific reference to the Federal Arbitration Act. That's what applies, right?
Yes, and that specifically is set forth in the deed itself. And however, this court also, in Global Travel Marketing v. Shea, said that the Federal Arbitration Act does not require parties to arbitrate when they have not agreed to do so. And in this case, the Hayslips never agreed to arbitrate.
Well, you're not saying it's the law under the Federal Arbitration Act that you have to sign a contract in order for arbitration to apply. You're not saying that, are you?
I'm not. There are circumstances where you would not have to sign an agreement to arbitrate. I will say, and I'm going to refer to the supplemental authority that U.S. Homes submitted to the court just last week, in an identical case to what we're dealing with here today. The case of Lennar v. Whiteley. This was an intermediate appellate court in Texas dealing with the exact same language that we're dealing with here today in the Hayslip case. And not surprisingly, because Lennar is the parent corporation to U.S. Homes. So we're dealing with the exact same language. And in that court, the Texas court said, to that point, Justice Polston, it said that, as a general rule, a party must sign an arbitration agreement to be bound by it. And yes, it's got the term generally. Generally, you got to sign it to know that you've agreed to it. You've intended to do it.
But there are circumstances under the Federal Arbitration Act in which they're not required to.
Sure. I acknowledge that. But what the intermediate appellate court in Texas also did was it analyzed, again, whether this specific provision in the deed touched and concerned the land. And the 14th Circuit Court of Appeals in Texas said it doesn't. And what it said was, covenants that do not burden or restrict the use of the conveyed property are not covenants that run with the land. And it went on to say, we conclude the arbitration agreement in the special warranty deed does not touch and concern the land. Therefore, it is not a covenant that runs with the land.
But the Texas Appellate Court specifically distinguished Hayslip based on Texas contract and property law.
It makes a reference to the fact that it was applying Texas law,
right.
And it cited the Hayslip case. And really, Your Honors, what I would say, and Justice Labarga, what I would say, is that what the intermediate appellate court in Texas said was, hey, this is an issue that's been certified to the Florida Supreme Court as an issue of great public importance. We don't agree with the reasoning of the Second District Court of Appeal. It's not persuasive to us. And hey, we think the Florida Supreme Court's going to fix it. In footnote 3, it says it's going up. It's a question of great public importance with wide-reaching impact. And so,
let me ask you this: can you give me an example of something that you believe touches and runs with the land?
Well, I think there's several good examples in the briefs. In the Winn-Dixie case, there was a covenant that dealt with the way in which other property owners in a shopping plaza could use their property. They were not allowed to also be a grocery store in competition with Winn-Dixie. There was the Dunn case, a very, very old case, also cited in the briefs, dealing with the inability to use a particular piece of property as a public bar, that sort of thing. Those are the types of conditions and restrictions that would run with the land. They immediately impact the land. In this situation, we're talking about an arbitration provision which is in this remote deed, and it just sits there. And unless somebody has a problem, unless somebody has a dispute, unless somebody has a claim for a construction defect against the builder, it has no effect on the use or enjoyment of the property whatsoever.
I have a couple of questions about the approach that we should take in deciding this case. Am I correct that the whole concept of real and personal covenants, including the test and the part of the test that deals with whether something touches and concerns the land, is common law?
Yes.
Okay. And so common law is developed by us, by judges, on a case-by-case basis. You get a unique set of facts like this. We haven't addressed this before. And don't you agree that policy concerns are appropriate consideration in a common law case like this? I mean,
I do think policy
Yeah.
concerns are appropriate to be considered.
I mean,
And
so-
I think Justice Lawson.
So the approach is not just, well, this case said this case said this, let's just figure out whether it touches the concerns. The real question is, what is the correct answer given the whole body of law and all other considerations that surround the issue? Would you agree that that should come into play?
Could not agree with you more completely. You got to look at the big picture.
Why wouldn't the presumption that is repeated throughout case law in favor of arbitration be a factor that we should consider in deciding this case?
Well, the fact that there is a judicial preference for arbitration.
What's statutory, that's sort of given to us initially.
And a statutory preference for arbitration does not mean that the court can create fictional agreements to arbitrate. It's still the case that somebody has to agree to arbitrate. Otherwise, they're being deprived of their access to the courts. They're being deprived of their access of the right to a jury trial. So that, I agree that public policy considerations should be taken into account, but that doesn't mean you take away folks' constitutional rights.
But I mean, that would be a factor, the fact that Congress and our state legislature has said that arbitration is preferred and that we should, in a case it's not clear, we should prefer arbitration, should be a factor that we should consider.
Yes, and those same courts have gone on, though, Justice Lawson, to say that simply because of that preference does not allow a court to force somebody to arbitrate who did not agree to arbitrate. There still has to be an agreement to arbitrate. And I would submit that although arbitration provisions may be favored, I would suggest that upholding constitutional rights is even more favored. And a party's right to have access to the courts, have access to a jury trial, are above the preference to arbitrate.
But the constitutional argument that you're making can be made about any arbitration clause. I mean, we get credit cards. We cannot live in society today, at least I can't, without a credit card. And as soon as you swipe the credit card that you get in the mail for the first time, you just agree to arbitration. And I would say that it is not quite as clear there that you're agreeing to arbitration as it was in this case where the deed is so specific about it.
And Justice LeBarge, I'd say there, that person is contracting and entering an agreement directly with the credit card provider. Here we're talking about a remote agreement. There was clearly an agreement between U.S. Homes and the original purchasers of the property 14 years ago.
But when the Hayslips bought this property, I take it there was a closing. At this closing, you have the deeds, you have all these things, and people sign documents and exchange the keys and things like that. I take it this was discussed.
They received a deed. They received their deed, not the deed that contained the arbitration provision. The arbitration provision that U.S. Homes is seeking to enforce is in a deed that was at the closing 14 years earlier between U.S. Homes and the Kennisons. So they were not provided that deed. They did not knowingly intend to enter into an arbitration agreement.
Counsel, you are consuming your rebuttal time.
Oh.
I understand we're helping you, but I want you to be aware of it.
No, I'd like to go ahead and reserve my
Okay,
remaining
and
time.
I'll give you 4 minutes anyway. Yeah.
Thank you, Your Honor.
Please the court. David Gersten of Gordon Reese, Scully, Manzucani on behalf of the respondent.
Counsel, could you speak up a little bit? I realize the mask.
I was going to ask if it's okay with the court if I remove my mask,
Oh,
because
certainly.
I don't speak loudly. I have a soft
Certainly. I mean,
voice.
if you're comfortable, I mean.
Well,
You can move the microphone down. It wiggles around. There you go.
thank you. Thank you, Justice Labarga. Your Honors, in spite of the protestations about the effect on the real estate market and the effect on real estate law, the real estate market and the real estate law have not been impacted by the Second District Court of Appeals Hayslip opinion, and certainly not adversely at all. The Second District correctly followed Florida precedent and utilized some on-point precedent from other states, Oregon, California, Illinois, and Oklahoma. And that determination from those states and with the Second District Court of Appeal is that the arbitration provision runs with the land. But I have to at least dispel immediately the concept that the petitioners had to sign the deed. That is not the law in Florida. The law in Florida, as indicated in my brief, is that it is signed by the grantor and two attesting witnesses. But the law in Florida from this court since 1903 in the Silver Springs Ocala Railroad case says that when you accept a deed and you take possession, that you also explicitly accept that you are required to do under the deed. And that case was followed 4 years later in the Taylor case. It has been followed consistently in the state of Florida by the district courts of appeal, taking you up actually to this court first, Bessemer, that you had mentioned, Your Honor, and then Winn-Dixie versus Dolging Corp. You accept the deed, you accept the possession of the property, you accept what the bundle of rights are and responsibilities and obligations are that are inherent in not only the deed that you get, and that the petitioner's deed here said subject to easements, restrictions, limitations of record, which puts them on notice under any circumstances. You're buying the most important thing you'll ever buy in your life, your house.
Counsel, could I
Yes.
ask you,
Yes, Your Honor.
could you give us an example of a right that could never be included in that bundle? That is, a condition in a deed that I don't see, a prior deed, that is nonetheless of record because it's been recorded, and therefore by statute I'm charged with knowledge of it having been recorded. Can you give us an example of some undertaking that some prior owner of a piece of property might have made that could not possibly bind me? Is there any such thing?
Absolutely, Your Honor. I believe it would be policy in violation of United States, Florida law, and every local concept of morality that you could not put a covenant in a deed about race or religion. Clearly, Your Honor. That would not be accepted, I hope, by any court in this country. So that would be an example. So,
Other than what is constitutionally barred, I'm with you.
right.
Is there any restriction on the use of the property or any restriction on disputes arising from the use of the property that would be prohibited? Or would any covenant relating to disputes about the property, say, for example, a waiver of jury trial or an agreement to mediate under the laws of France, would those things be acceptable as conditions in a deed?
Well, Your Honor, you posed an interesting question under the law. Mediate under the laws of France.
Pick your poison.
I get it. I get it, Your Honor. I think you would first have to take a look at this exact arbitration provision first. That would be the first step in an analysis. And when Your Honors view the deed, which is in Respondent's Appendix 8 through 11, and you go through it carefully, this is a special warranty deed that covers exactly what you must arbitrate. And I will get to an example here where maybe it doesn't apply. But it specifically states that you would have to do it whether contract, warranty, tort, statutory, or otherwise. So I might call the attention, Your Honor, under this arbitration provision that we're dealing with in this case, perhaps a tax dispute. That might not be covered under this arbitration provision. That's the poison I'm picking in this instance, Your Honor. There could be others, but that's what comes to the top of my mind at the moment. But it is important also when it comes to touching and concerning the land, that test, and Chief Justice Kennedy, it is an amorphous test. I'll agree with you. It's kind of, you know it when you see it, and in this case, clearly it must touch and concern the land because it concerns your house, okay, your veritable castle and the use and enjoyment. And that's what the Second District Court of Appeals, that this is a way to resolve. And in this instance, Your Honor, we're talking about stucco. And stucco is something you would apply to the structure of the house. It's non-structural for decorative purposes. You take pride in your house, you want it to look good, and if you have a problem with how your house looks, you're upset. That certainly touches and concerns your interest in your house, unquestionably. And this arbitration provision, which is why it's favored policy, Justice Lawson, policy, the United States Supreme Court, this court, every district court of appeal, every circuit court and county court recognizes the obligation to honor arbitration under 9 U.S.C. et sec. And not only that, when we talk about policy, the true policymaker really is the legislature to begin with, because they're the ones that determine policy. If there's a void, the Supreme Court, of course, steps in and determines policy as well. And by the way, Justice Polson, that's what you had said in your Saunders case. You were on that one back in the old days when you were on the first DCA. So aside from that, when we talk about policy, let's see what the legislature said. And Chief Justice Kennedy, you brought up a homeowners association. It's as if you were reading my notes to the court. Because under 720, which is the homeowners association.
Let's make very clear I did not.
I clearly you did not, but actually I want to look at your notes. But aside from that, Your Honor.
I read your brief. I'll interject here. That both sides, your briefs on both sides here, I thought were excellent.
Well, thank you. So I appreciate that very much, Your Honor. But when we talk about the policy and we look at 720, which is the homeowners association, which in this very case, under the deed, Your Honor, where I have pointed Your Honor's attention in the appendix, under Section F, the Hayslips, the petitioners, are bound to be members of a declaration of the homeowners association. They didn't agree to it, but they are. But when we look at that statute, which is 720, Your Honor, 720.311, the legislature finds that alternative dispute resolution has made progress in reducing court dockets and trials and in offering more efficient, cost-effective option to litigation. And as in my brief under Section 558 of the Florida statutes, the legislature also steps out and talks about the importance of ADR. Courts are busy. We all know that. ADR is a way to relieve it where an aggrieved person has a forum where they can have their grievances heard. And I think it is important in this case when we think about the bundle of rights that we have with our property, you know, the possession, the control, the right to exclude, and additionally the right to sell your property or dispose of your property. With that, you are disposing that which the bundle of rights that you have exist. You can only give what you have. And in this case, the deed before the petitioners is the deed in the public record, Your Honor, and Florida is a public record state, make no doubt about it. Please make no doubt about it, since 1932, at least, or earlier. This court has clearly said that Florida is a notice state. That's Sapp versus Warner, which is briefed. This court in Cape Sable versus McClurg, approximately 20 years later, says that purchasers take title subject to all the CC&Rs, for lack of a better word, it's quicker, CC&Rs that exist concerning the property. And the cases go back to saying, from the beginning, it's not just the deed that you receive. And again, the petitioners received a deed that says, hey, check the easements of the property you're buying. Check them. Maybe you don't want to buy that property. Maybe you don't like what the easements say. Maybe you want to graze cows and you can't. You want to know about that. But they didn't do it. They didn't lift a finger. But U.S. Home, the respondent, did everything it was supposed to do that the law requires, which is to place it in the public records. And I believe, Chief Justice, it was you again that said it, or I can't remember, Justice Polston. It's a public records issue where if you come to the state of Florida, and I don't care if you get here by car, train, plane, bike, skateboard, it wouldn't make a difference. When you come into here, you are presumed to know the laws. So ignorance is no defense, and you are presumed under public records to know what the public records are, and ignorance is no defense. And it's not because I say that, it's because the cases say, this court has said, you cannot shut your eyes and ears to information that is available and then step back and say, I didn't get notice. And that's in the case law. That is in the jurisprudence of this great state. And the irony here, the real irony, is that had the petitioners followed what the magistrate judge said that you should arbitrate, but they didn't, had they had followed what the circuit court judge said, but they didn't arbitrate, had they followed what the district court of, three judges on the district court of appeal unanimously stated in a well-reasoned opinion you should arbitrate, this is a 2017 case. It is now 2021. The merits of the underlying claim of the petitioners have never been heard. And had they have used the policy of arbitration being favored, and what the legislature tells us, it's quicker, it's less costly, certainly in a matter of months, they could use and enjoy their house, their castle, they could have their stucco repaired if indeed it was a meritorious claim, and we wouldn't be here today. So I can only say that this arbitration clause does not upset any of the laws of the state of Florida, is consistent with policy, and if there's no other questions, Your Honor, I guess I should rest on my, what did you say, Chief Justice Kennedy, about that brief? Well-written brief. I appreciate that.
Both, I said both sides.
Well,
Don't rest too comfortably.
I'm not, Your Honor, but if there's no further questions, well, thank you, and I rest on the brief then. Thank you very much, and I'll put my mask back.
Mr. Carrillo, you're right. There's no provision that you couldn't put into a deed. Nothing that you couldn't put. And then by the argument of constructive notice, everybody is now going to be bound to whatever.
But the touch and concern is amorphous, as we have discussed, but it's not meaningless. Now, I'll give you an example of something I think would be problematic. Say there's a covenant that says that the subsequent owners of the land shall make a contribution, an annual contribution of $1,000 to the Shrine of Moloch, 10 miles down the road. I'm not sure how that would touch and concern the land. And I bet you there have been a covenant similar to that, maybe not of that exact nature. So there are some outer boundaries, even and furthermore, we don't even in this case we don't even have to decide that everything addressed in the particular covenants here touch and concern the land. We've just got to address the specific one relating to this arbitration of construction defects. Isn't that correct?
Yes, as to this case, but I think it's going to have wide sweeping consequences to deal with other provisions that builders or other property owners are going to try to insert. Simply, for instance, maybe next you're going to see an indemnification provision, a hold harmless provision, a liquidated damages provision. Here they've already, not only by virtue and encompassed within the arbitration provision, they're having the property owner give up their right to a jury trial. They actually have a separate waiver of jury trial right in the deed as well. Not only do they have that, they also have an attorney's fee shifting provision in there. Under Florida law, the only way you get attorney's fees shifted is by contract or by statute. And they've put that in there too. I mean, there's an endless supply of things that could be inserted into a deed if the court were to find that, hey, it's okay to force them to arbitrate just because there's a judicial preference for arbitrating. Well, the legislature, they could have made everybody with a construction defect claim arbitrate if that's what the legislature wanted them to do. But they didn't. They make them jump through a whole bunch of hoops under Chapter 558 before they can ever actually file a lawsuit against a builder for a construction defect. And now, on top of that, now you're going to have to decide whether, oh, well, now you're going to be forced to arbitrate too, even though you didn't agree to it, and somebody else did it for you. Somebody else waived your jury trial right. Somebody else waived your right to seek access to the courts. And I would submit that, okay, yeah, maybe their case would have been resolved years ago had they just acquiesced and gone along with this arbitration provision in this deed that they were not a party to, that they never agreed to. But then everybody else is going to also be forced to do the same thing. And the Hayslips, it's important to them that they have the right to a jury trial. It's important to them that they have right to the access to the courts. And I would say that this court should uphold their Florida constitutional rights to a jury trial and access to the courts above U.S. Home's desire that they submit themselves to arbitration. And if there are no further questions, I will rest with that. Thank you.
Thank you. Thank you, counsel. We thank both of you for your arguments in this case. The court will now stand in recess, and at 10:30 we will continue today's proceedings virtually.
I think right now we're on track for 10:30.
Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning. The first item we take up now is a judicial reprimand arising from an inquiry concerning Circuit Judge Scott Cupp. Judge Cupp, you are called before the court today because of misconduct under the Code of Judicial Conduct. This is a difficult day for you, for us, and for the entire state judiciary. Whenever a judge violates the requirements of the code, damage is done to the public trust and confidence in our state courts. I know that you recognize that this is a very serious matter. As judges, we enforce the rules of the law on the litigants who come before us. As rule enforcers, we must be rule followers. When judges fail to follow the ethical rules to which they are subject, the integrity of our system is brought into question. The effectiveness of our judiciary ultimately rests on the trust and confidence that the people confer upon judges. Although we cannot roll back the clock and undo your misconduct, we have commanded you to appear today for a public reprimand as one way of addressing your violations of the code. By doing so, we assure the public that we take misconduct by a judge very seriously and that we will not hesitate to punish errant judges in a most public way. Judge Cupp, you have stipulated to the charges against you and therefore publicly acknowledged your misconduct. You also agreed to this public reprimand. According to the stipulation you reached with the JQC, you admitted that in the lead up to the 2020 election for Hendry County Court Judge, you began contacting individuals you knew in the county to inform them that you were supporting the incumbent judge's opponent because of concerns you had heard about the incumbent. Your preference for the incumbent's opponent eventually became widely known in the community. You admitted that you contacted influential members of the Hendry County community and expressed your preference for the incumbent's opponent in that judicial race. In some instances, you specifically requested that the community members support the candidate you favored. This contact was inappropriate and violated canons of judicial conduct 1, 2B, 7A1B. It damaged the integrity of the judiciary by creating the appearance that you were interceding in a judicial election. You have also admitted that you violated Canon 7 and Chapter 106 Florida statutes during your 2020 re-election campaign. Specifically, you failed to officially designate a campaign account and treasurer with the Division of Elections prior to receiving any contributions or issuing any funds. This conduct further damaged the public's perception of the judiciary. To your credit, Judge Cupp, upon being presented with the notice of investigation, you took immediate responsibility for your conduct. You did so in both your written response and during sworn testimony before the JQC. You admitted that your conduct was inappropriate and violated Canons 1, 2, and 7. You have expressed regret that your conduct damaged the integrity of the judiciary and the public's perception of the judiciary. In considering this matter, the court has also weighed the fact that you have no prior discipline imposed by the JQC. You have been licensed to practice law for over 34 years and have had no prior disciplinary history with the Florida Bar. The JQC was also persuaded that you will never again engage in such misconduct. In keeping with our own view of the record and your stipulation, we required you to appear before the court for this public reprimand. This reprimand, like every reprimand, should serve as a sober warning to any judge who does not take seriously the obligations imposed by the code. Judge Cupp, for your violations of the Code of Judicial Conduct, you are hereby publicly reprimanded. We trust you will faithfully follow the obligations imposed on you by the code from this day forward. As our case law establishes, and as you well know, any future misconduct will be viewed far more harshly. Thank you. That concludes this reprimand. will now prepare to take up the next case on our docket.
Mr. Rothenberg, can I have this contract number 10? Do I clear? How do you read it? The court will now take up the case of the Florida Bar versus Schwartz. Counsel for the bar is recognized.
May it please the court, my name is Chris Altenberg. I'm a member of Banker Lopez Gasper. I'm here this morning representing the Florida Bar. I'd like to say 3 minutes for rebuttal. This is the final review hearing concerning the sanctions imposed in case number 17-1391. This sanction will presumably run concurrent with the 10-day suspension recommended in case number 19-983. The issue here is whether the referee's recommendation of a second 90-day suspension or the seventh disciplinary proceeding is reasonable under the standards of the case law, or whether a longer rehabilitative suspension should be imposed. The outcome of this case probably depends upon whether the bar or Mr. Schwartz has correctly read this court's last opinion. In obtaining a recommendation of a second 90-day suspension from the referee, Mr. Schwartz explained, his lawyer explained, so why are we here? We're here because the Supreme Court determined that the law does not allow, despite a good and honest motive, despite no intention to deceive, despite having tried to apply the law, Mr. Schwartz did in fact violate the law by using a lineup that he created. And then he went on to say that his client didn't know he was doing wrong at the time, and the Supreme Court essentially acknowledges that, and he did not do wrong for any improper purpose. He just did wrong because the law says you can't. It's a defense function that defense can't confront a witness in a deposition with a defense-created lineup in an effort to create a misidentification. Now, if what Mr. Schwartz told the referee is actually what you intended in your last decision, then perhaps a 90-day non-rehabilitative suspension like the one he received when he falsely notarized the documents that his client had not signed in 2012, that might be sufficient, but I don't read the opinion to say that. Concerning intent, I admit that this court in the last opinion did not go through each and every finding in the earlier report to accept and reject those findings separately. But this court made very clear that Mr. Schwartz was wrong in his argument that he lacked the intent necessary to violate the rules. This court explained that the proper issue in a disciplinary proceeding is an intent to commit a deliberate and knowing act that violates the rules. Here, Mr. Schwartz clearly committed acts that were not just knowing or intentional. This was a complex, premeditated plan to cause the victim of an armed robbery to misidentify the perpetrator she had previously identified. He had his associate undoubtedly spend a considerable amount of time to remove the photograph of his client that the victim had circled and signed and insert someone else's photograph, keeping his client's hair still in the picture. He did this because he wanted her to rely to her detriment on the misrepresentation that was contained in that photograph. That's fraud. Now, he didn't expect that the witness would have as good a facial recognition skills as she did, and she balked on that, and we discovered it after the fact. He claims before the referee and repeatedly before this court that he did not conceal this from her in the deposition, that he fully cautioned that this was his own lineup photograph. I would simply ask you to read pages 25 to 30 of the deposition itself and decide for yourselves whether that's true or not. It appears to me that he did not disclose that to the victim, nor did he disclose it to the assistant state attorney. As to motive, and I think he conflates motive and intent somewhat in his arguments. Your last opinion made clear that motivation is not usually relevant to the commission of the violation, but it's almost certainly always relevant in a sanction hearing. Here, the second referee did not find one way or the other whether Mr. Schwartz had a selfish or deceptive motive. Part of what motivates Mr. Schwartz seems noble: to provide the best defense to his client. This is a constitutional ideal that all good criminal defense lawyers should strive for. But a lawyer must strive for the best defense that can be presented within the law. It is not a noble constitutional ideal to decide that the ends justify the means, that is an abandonment of the rule of law. And the bar submits that the goal of winning at all costs without regard to the rule of law is dishonest. And it is selfish in that it puts one's personal desire to win over the proper administration of justice and over the rights of the victim of a violent felony. Now, as to the standards, I won't go through all four standards that we have discussed in our briefing. I think they're adequately covered in the briefing, but I would make two comments about them. First, the standards are general standards of application. And when it comes to a suspension, they don't help this court decide whether it's a non-rehabilitative or a rehabilitative sanction. And they don't help this court decide whether it's 10 days or 3 years. And so you need to look at additional factors to help you decide where on the spectrum a particular case falls. I have argued the disbarment provision in 5.1 and 8.1, not because the bar is seeking disbarment in this case, but I would submit to you that when there is more than one standard that clearly applies to a case, and here there's at least 3, if not 4, and when one of the options would actually be disbarment, that should be a good indicator to you that we're talking in the range of a rehabilitative sanction of suspension rather, and that probably that suspension ought to approach the 3-year end because disbarment is the only thing above the 3-year suspension. Now, as to standard 8.1, it says that disbarment is appropriate when a lawyer has suspended for the same or similar misconduct and intentionally engages in further similar acts of misconduct. Well, these acts aren't identical, obviously, to what happened in 2012 when he faked the notarization to help his foreign client. But each involves a serious misrepresentation of the evidence in an effort to win. Each is a case where he decided that the ends justified the means, and that each is a case where he intentionally disobeyed the rule of law and interfered with the administration of justice. The bar submits that for purposes of selecting a sanction, these are similar acts of misconduct. The aggravating factors in this case have been well briefed. I don't think I need to go through them completely with you. I would comment that there is a pattern of misconduct here. It's a pattern of deceit and misrepresentation. It involves 4 prior proceedings and 9 separate violations. He has tried to offset this pattern with the mitigator of interim rehabilitation because he went to see a psychologist. But from his own testimony and from the explanations he provided to that psychologist, we know that even after therapy, he thinks he only pushed the boundaries and that he did not cross them, that he's just overzealous in his representation of his clients. And he only plans to do this, this specific conduct again. He still doesn't understand it's the rule of law that's his prime directive and that he can't justify the means by the end goal of trying to win. That's what he doesn't understand. And this is a seasoned criminal attorney, not a green PD. He's only recently completed a 90-day suspension for other deceptive acts. This is a chronic problem. It is not a one-off misjudgment. You know, I would like to comment too that when it comes to the mitigating and aggravating factors, the referee's job is to help you by finding the fact of those factors. But the far more difficult task here is trying to decide how you apply them, how you balance the mitigators and the aggravators. And one of the reasons that I think ultimate decision on sanctions stays with this court is that the referee, first of all, rarely ever discusses how they do the balance. And secondly, they're doing it for one case only. This court has the unavoidable and probably not pleasant task of trying to balance these things in each case that comes through here. And that is a mixed question that you don't really have to defer to the referee on. The case law in sanctions, frankly, from my limited experience in the last 1.5 years, rarely has a case that's directly on point. And that's probably a good thing because it shows that we don't have a lot of cases annually from which you can make these decisions. But I would submit that you use the case law more like you would do in divorce for equitable distribution or alimony. That it helps you create this range in which you can operate. And then you can look at the circumstances of the case to figure out where along the range it should be. In the cases we have cited, I think say that the range is rehabilitative. And I think it's the longer end of rehabilitation here. The most similar case is the Dunn case because it's also recent. That was a prosecutor. She was a young prosecutor with no prior violations. She didn't disclose some Brady information she should have disclosed. But after she had that problem, she would talk to her supervisor, and they immediately tried to take steps to resolve it. Now, she made the further mistake of then saying, oh, but the defense attorney had equal access to this information. And that was just false. Now, Mr. Schwartz is a defense attorney, but I don't think that these professional obligations fall only upon prosecutors. The rule of law falls on both sides.
Counsel, I'm sorry to interrupt you. Can I just ask a quick question?
Sure, absolutely.
Is the motive issue the reason why the bar isn't seeking disbarment here?
You know, that's a good question. We have two cases pending right now, and we haven't asked them to be combined for a single sanction. And the last time was a non-rehabilitative sanction. So jumping all the way from a non-rehabilitative beyond the 3-year suspension to disbarment, I think has been the slowdown in this case. You know, I don't believe that the bar thinks that there's any difficulty with motive here. Your last opinion is a little unclear to me on that, but it seems to me that his motive was to have her identify the person inside her circle. And however you want to characterize that with other words.
No, I mean, I mean, look, I don't think that we could have found that there was a violation of the rule without finding that there was an intent to deceive. The way I understand the opinion is that it said that to the extent that part of the motive was zealous advocacy for his client, that is something that maybe could be looked at in terms of mitigation or the sanction or whatever. But, you know, I mean, if we didn't think that that it was intentionally misleading conduct, then I don't see how we could have found that there was a violation of the rule in the first place.
Correct. And so, I mean, you're right. When we come back to the hearing here, we get to the motive, and the motive is ultimately for you to decide from this evidence. But it seems to me that this isn't a simple, honest mistake. He said he had read the law. The law clearly did not support him on that. So I see I'm down to 2 minutes. I'd like to save the rest of my time for rebuttal, if I may.
Very well.
Thank you.
Counsel for the respondent.
Good morning, Chief Justice and Justices. My name is Ben Cuney. I represent Jonathan Schwartz, a 35-year lawyer practicing almost exclusively criminal defense, providing criminal defense representation to clients, most of whom are fairly able to raise funds to support their defense. He's done this decently and with zealousness for 35 years. And in this particular matter that's before this court, he has recognized in his extensive testimony to the referee, subject to full examination by the Florida Bar, that he absolutely understands what he did wrong, acknowledged that he did wrong. He created, not with extensive planning, the testimony reflects undisputed, he created his own version of a lineup in an effort to test the verifiability of the witness's police photo lineup that had certain constitutional implications. And he did so in a way that he should not have.
Counsel, you say it's not with extensive planning, but this is not just something that popped in his mind when he's sitting there at the deposition. He fabricated this document in advance. Isn't that correct?
Mr. Chief Justice, absolutely. And he has made clear that he did that. He did that in preparation for the deposition to create his own version of a lineup, and did that. He did not use a color scheme that in any way resembled the color scheme that the police utilized, but his effort was to test. He thought it would be helpful on a legitimate misidentification case. And he acknowledged it was the wrong thing to do. And his presentation to the victim in the presence of an aware, experienced prosecutor included a distribution of the documents. And although off the record, when the prosecutor raised an objection, The testimony was clear. He fully explained to the prosecutor what he had done, how he had done it, and his purpose in testing the verifiability of the affidavit, of the lineup. He did not hide it. And when the prosecutor said, I'm objecting under the law, he moved on to another item. And
Counsel, I'm
Yes.
sorry to interrupt you. Can I just clarify something with you? And I think that you personally have done the best you can with the advocacy. I thought you had a great brief with a tough case. I don't think there's anything noble or admirable about what your client did. But I just want to ask you, if you assume that we found in the first case that it was intentionally misleading, then could you just, I suspect you dispute that, but let's just assume that that's how we read the case, or at least how I read the case. Then given our case law, given the fact, the prior disciplinary history of your client, could you kind of give us the best argument for how you could justify having a non-rehabilitative suspension under those circumstances?
Thank you, Justice Muniz. And to be clear, the entirety of the sanctions proceeding has been based on the recognition that this court said his conduct was intentionally deceptive, but he presented what he believed the court allowed him to do, which we think is always appropriate, the motivation, what was going on in the process of doing that, not to underplay the very serious gravity of this misconduct. And in essence, Mr. Schwartz accepted full responsibility for his misconduct, disclosed all the relevant facts in real time to the prosecutor, did not act on any of the effort for misidentification. The matter was stopped. He removed himself from the representation of that client because he knew that there was the potential to not be able to effectively represent his client, all of which is undisputed. And ultimately, the client received the benefit of a true misidentification concern pursued by the substitute lawyer and received boot camp. With regard to Mr. Schwartz's conduct from 2015, in furtherance of the 90-day suspension, Mr. Schwartz has engaged in significant rehabilitation, has consistently reported to judges and others, and Judge Millian testified extensively that he has not shirked from his recognition that he has done wrong, and the testimony reflects his entire law practice has changed as a result of this case, this reality, and the near 7 years that it has been pending. Much fewer cases, multiple lawyers assisting in every single case. So all issues about how to practice law professionally but zealously are evaluated with a colleague, an associate.
So can I'm sorry to interrupt you. So can I,
Yes, sir.
I just want to make sure I understand. So there's the subsequent rehabilitation, which I understand, but then as to the conduct itself, I mean, is your argument that because once he was called on it by the prosecutor that he, I guess, stopped? I mean, is that supposed to be in our minds the critical fact? Because I don't really, given the exchange that took place and that she basically kind of called him out on it, what was he supposed, what other alternative did he have at that point?
Your Honor, this court has identified, and particularly the Dunn case is a great example. What does somebody do when the contours of their lawyering stretches the allowable boundaries is wrong? Does that person deny, delay? In Dunn and in Cox, this court found that that type of what we'll refer to as the cover-up is the indication that the entirety of the purpose was invalid, and the person did not recognize the enormity, the gravity of their error. Here, Mr. Schwartz absolutely did wrong, but when, as Your Honor has said, called on it, immediately stopped, but didn't just stop, essentially fully disclosed exactly what had happened, what he did and why he did it. And he then moved on and removed himself. So it's not a, I'm caught, therefore I've got to change my story, as unfairly too often happens with lawyers who get caught. Here, he was challenged by an astute lawyer representing the interests of the victim, the witness in this case, and he made clear what he had done and abandoned any further effort to pursue that misidentification and pass the case to a lawyer independent of any of his interaction with the prosecutor. Those are the kind of rehabilitative steps, recognition steps that this court seems to have acknowledged were not present in the Dunn case or the Cox case, but more likely present in the cases where lawyers' conduct is met with a ready recognition of impropriety and a demonstrated basis to do better, to rectify the misconduct, to learn from that in real time, not waiting until
Counsel, you know, I'm sure we've had other cases before us that have had prior disciplinary records that were as extensive or more extensive. But this does stand out. I mean, is it 7 cases? And then we have some other matters pending. What do we do with that? Doesn't that weigh in a significant way against your client in terms of rehabilitation and understanding? He's been entangled with our disciplinary system multiple times over over the course of his career. And I just, at some point, it's not working. So tell me why we should just kind of put that aside, or what we should do with it.
Mr. Chief Justice, Mr. Schwartz does not ask this court to put that aside, but ask this court to see that, as the court is allowed to do, in the context of this case and his conduct in other cases balanced against his career. This court always, in disciplinary cases, and these are difficult, they're among the most difficult responsibilities of this court in overseeing members of the Florida Bar. But still, did the referee, in evaluating all the facts, listening to the witnesses, hearing what is said, not just what is said, but how it is said, what it means, did the referee recommend a sentence, a punishment that is fair to society, protecting the public, and allowing lawyers to continue to utilize their services for those in need? Is the sanction fair to the respondent? And does the sanction effectively deter? There is no doubt, Your Honors, from the publication of this court's opinion, and Judge Millian and other witnesses testified about it within the Miami-Dade County criminal defense community where Mr. Schwartz primarily practices. This conduct is well known and is highly discussed about lawyers and how careful lawyers must be in their obligation to do justice. And with regard to having been before the bar in other matters, it is not an escalating pattern of misconduct, Your Honors. There are conduct where Mr. Schwartz readily identified his misconduct and resolved with a consent agreement. The most serious of which the Florida Bar points out is what they call the false affidavit, an affidavit that was signed by Mr. Schwartz telephonically, virtually, with a client who could not return to the United States. And Mr. Schwartz made no pretense that he had signed it for his client. The document itself shows his initials. Mr. Schwartz made no pretense that the client appeared before him on the notarization. Mr. Schwartz explained this in the proceedings on a financial affidavit.
But if it's wrong, it's still wrong. Just the flagrant doing the act in full view doesn't make it okay. Someone walks into a store in full view and walks out with merchandise, it's still stealing, even though they do it in full view of everyone. You know, it's still a problem.
Justice Polston and Mr. Schwartz in that matter and in this matter recognize that. Although the law has distinctively changed from that time, he should not have done it. He should have obviously not submitted anything, even though he submitted the affidavit based on information that his client said was true, and he essentially acknowledged that and submitted that to the court. He's never walked back from that saying, I didn't do wrong. He should not have submitted anything that said notarization. But is that the kind of misconduct that is escalating in nature that causes this court to say a 90-day non-rehabilitative suspension cannot in any way assure the purposes of discipline in this matter? The referee did her able best, tested by lawyers for the bar and lawyers for Mr. Schwartz, and achieved a resolution recommended to this court that balanced all of the factors, including Mr. Schwartz's conduct in other cases, advertising violations, failing during a very busy time of practice at a time when lawyers, he had substitute counsel and missed court hearings and acknowledged what he did. And those matters are not indicative that Mr. Schwartz is incapable of professionally and properly dedicating his license to practice professionally in a way that commands attention to all the guidance of this court and protects the public and his clients. We ask for an affirmance, Your Honors.
Thank you, counsel. Rebuttal argument.
In 1937, this court declined to integrate the bar into the judicial system. Following the collapse of the judiciary entirely in Nazi Germany and the experiences of Justice Sebring when he left this court to preside at Nuremberg, this court in 1949 changed its mind and integrated the bar, making lawyers literally officers of the court. You did that because you'd learned from history that the survival of the rule of law and the independence of the judiciary necessary to preserve the rule of law needed an army of lawyers committed to its defense, that society would never have faith in the rule of law unless the court and its lawyers were fully committed to this basic proposition. At the time, the court explained the assault on our institutions, which the bar is expected to take the leading role in challenging, also requires the impact of the full power of the bar. Now, the bar prosecutes cases involving deceit, especially cases involving the ends justifies the means mentality, not merely because that's a character flaw, but because it strikes at the whole foundation of the rule of law. And Mr. Schwartz, after all of his history of discipline, still thinks that what he's doing is zealous advocacy. We've discussed the three purposes here. I would point out that they were first announced in Pahulis in 1970. In 1970, there were 10,000 lawyers. Today, there's 110,000 lawyers. The beginnings of profession, we could not advertise at all, and reluctantly only thought of ourselves secondarily as a business. And it's been transformed into a business that is marketed even by text messages to strangers. The reasons that this court announced a policy of harsher sanctions is not because you were bullies, but because the health of that army of lawyers needed to deal with the society's conditions today, especially to guard against the ends justify the means. And I would submit to you that those three purposes, in light of today's conditions, warrant a 3-year suspension in this case. Thank you for your time.
We thank you both for your arguments in this case today. That's the final matter on today's docket. So this session of the Florida Supreme Court is now concluded.
Thank you, Your Honors.